The Role of Hadith in Ikhtilāf among Muslim Jurists by Musaed Salem Abdulkader, a Master of Arts thesis submitted to Mcgill University in Montreal, Canada, February 1983. The abstract. This thesis is an attempt at studying the role of Hadith in Ikhtilāf among Muslim jurists. This Ikhtilāf can be traced down to many causes, the most important being the Hadith. However, no deep study has been conducted on this subject, neither in the past nor in the present time. There is only one work that deals with this topic, which can be by no means a comprehensive study of the subject. This Hadith would highlight the nature, the extent of Ikhtilāf among the jurists, and the consequences that flowed from it, perhaps the most important being the appearance of many juristic trends and law schools in different parts of the Islamic world. Table of contents. So, after the introduction, we have chapter 1. This talks about Hadith, its kind and impact on jurist disagreement. The Mutawatir Hadith, the Ahad Hadith, justification for overruling Ahad Hadith, overruling of Ahad Hadith incompatible with Qiyas, rejecting Ahad Hadith pertaining to widespread habits and matters, rejecting Ahad Hadith which are not observed by their narrators, rejecting Ahad Hadith forgotten by their narrators, rejecting Ahad Hadith pertaining to penalties, rejecting Ahad Hadith in conflict with Medinan Amal, the approach of the companions towards Ahad Hadith. Chapter 2. The acceptable Hadith, Sahih Hadith, Hasan Hadith, the rejected Hadith, Da'if Hadith, Mursal Hadith. Chapter 3. Naskh of Hadith and juristic disagreement, kinds of Naskh, conditions of Naskh, how to distinguish a Nasikh and Mansukh, juristic controversy arising of Naskh. Chapter 4. Conflict in Ahadith and the rules of preponderance, Ta'arud, conflict, conditions of Ta'arud, and Tarjih, preponderance. Epilogue, glossary, bibliography. Introduction. There is no disagreement with regard to Quran and Sunnah being primary sources of Islamic law. The same is the case with regard to consensus and analogy, though some law schools, such as the Zahiris, have refused to consider the latter as a source of legislation. There is, however, disagreement with regard to the secondary sources, such as public interest, legal opinion of the companion, and juristic preference, etc. It would be interesting to note at this point that the majority of the Sharia rules are deduced from the 4 primary sources, which, as indicated above, are overwhelmingly accepted. However, there has been a great juristic disagreement on the various juristic rules. This disagreement encompasses the whole field of fiqh. This means that this disagreement only in furuh, details. In other words, juristic disagreement does not concern the authority of the Quran and the Hadith as the primary legal sources. It is mainly on matters of interpretation and the correct understanding of these sources where the causes of disagreement should be sought. The disagreement in details can be traced back to the period of the companions. However, there was no such controversy at that time of the Prophet, because the continuation of the revelation in his lifetime and his own presence would have settled the matter whenever disagreement occurred. After the death of the Prophet and the discontinuation of the revelation, disagreement among the companions did not take place, but it was not very serious. The credit for this goes to the early caliphs, who established modes of legislation by referring a new case to the Quran and the Sunnah. If they did not find anything in the above sources, they would ask the people if anyone knew a hadith of the Prophet in this regard. Failing this, they consulted the people and tried to reach a consensus. Unfortunately, this practice did not last long. The companions were dispersed in different cities, and it became impossible that they get together and reach a consensus on every new issue. Some of these companions were scholars and jurists. They gave legal opinions, everyone according to what he thought best. This is in fact the nature of their disagreement, and the disagreement of their followers afterwards. We can therefore summarize the causes of the disagreement as follows. 1. Disagreement in understanding and the interpretation of the Quran or the Sunnah. 2. Disagreement due to the ignorance of the Sunnah. 3. Disagreement due to non-availability of a nas in a particular case. 4. Disagreement due to doubt in the authenticity of a hadith. Many scholars have written on this topic, but they have not encompassed all the aspects of the subject. Existing literature on this subject is of a general nature and does not give adequate attention to the basic causes of disagreement or discuss them in details, except perhaps one study which was carried out by Muhammad on the role of hadith in the disagreements of the jurists. Juristic disagreement has been a subject of study for a long time, and many books have been written in this field under the title of Ikhtilāf or Al-Insāf, but very few works have been published. There are works which are still in the form of manuscripts. The first book in a published form is that of Batlayusi, titled Al-Insāf fi Tanbīh ala al-Asbāb allati awjabat al-Ikhtilāf. This book deals mostly with the linguistic aspects of the disagreement and not the juristic one. The first 4 chapters are devoted to the linguistic aspect of the subject. Only the 5th chapter related to the hadith as a cause of juristic disagreement. The emphasis in this chapter is also on the linguistic study of the hadith. Batlayusi discusses qiyas in the 6th chapter, naskh in the 7th, and ibaha, permissibility, in the 8th. This is the scheme of the book. Another work published on this subject is Raf' al-Malam and A'immat al-A'lam by Ibn Taymiyyah. He discussed the role of the hadith in juristic disagreements and the causes that called upon the jurists to abandon practice on the certain hadith. Ibn Taymiyyah also criticized taqlid, which was prevalent in his time. Even scholars, let alone the ordinary people, called for the closing of the gate of ijtihad. Also of interest on this subject is a small treatise by Shah Waliullah al-Dihlawi entitled Al-Insāf fi Asbāb al-Ikhtilāf. Dihlawi mentioned a few examples of the disagreements of the companions that eventually resulted in the establishments of 2 schools of law, a school of Ra'i and a school of Hadith. He ends his treatise with a study on ijtihad and taqlid. This briefly summarizes the works that reached us on the subject of disagreement of the jurists. To the best of my knowledge, all other works are still manuscripts, such as Al-Iqaf ala Asbab al-Ikhtilāf by As-Sindi, and number 2, Jazil al-Mawahib fi Ikhtilāf al-Madhahib by As-Suyuti. As for those who touched upon this subject in their books but did not deal with it exclusively, there are many, such as Ibn Rushd in Bidayat al-Mujtahid, Ash-Shātibi in al-Muwafaqat, and others. Modern studies on this subject are very few. In fact, as far as I know, their number do not exceed 6. They, according to their dates of publication, are as follows: Asbab Ikhtilāf al-Fuqaha of Khafif, Athar al-Ikhtilāf fi Qawā'id al-Usuliyya by Al-Khin, Asbab Ikhtilāf al-Fuqaha by Turki, Dirasat fi Ikhtilāf al-Fiqhiyya by Bayanuni, Asbab Ikhtilāf al-Fuqaha by Az-Zulaymi, and Athar al-Hadith fi Ikhtilāf al-Fuqaha by Muhammad Awama. Dr. Khafif's book is an extensive study and is considered as an important reference on the subject. This is due to the deep and comprehensive research undertaken by its author in this field, though in my opinion it lacks proper arrangement. The reader comes across his conclusions here and there, and they have not been discussed in a separate chapter. This has made the study of this book very difficult. As for the study of Al-Khin, it concerns the basic principles and the effect of the disagreement of the jurists over them. Therefore, this study is very well arranged and throws light on the personality of the author and his independent approach. He has added much more to the subject, as is evident from his discussions with the ulama. Turki's book adds nothing new to the subject. Bayanuni has adopted a different method for discussing the moral aspect of the juristic disagreement. This disagreement, Bayanuni believes, should not divide the Muslims into groups, for Islam endorses disagreement of opinion. Every mujtahid expresses his opinion according to this ijtihad. Zulami's book is not immune to criticism. However, he is the only one who mentions, though very briefly, other studies undertaken in this field, such as Al-Khafif's study. Awama's book is the only work that deals exclusively with the hadith being one cause of disagreement among the jurists. But his study is not comprehensive in the sense that he does not deal with all the aspects of the subject. This, I think, was a natural outcome of a scholarly mistake on the part of the author. He arrives at a conclusion first, and then starts to explain material that would corroborate it. He advocates taqlid very strongly, and upholds that no one today exercise ijtihad. The safest way, therefore, is taqlid and to follow the accepted imams. This study contains many scholarly errors. I may give examples in the course of my thesis. My opinion is that the hadith has a very important factor in the disagreement of the Muslim jurists, and no author has singled out hadith from this perspective before, except for Awama, who I mentioned earlier. Therefore, the study of the role of hadith, its bearing as an important factor in difference of opinion of the Muslim jurists, is distinctly needed, especially after the appearance of a new trend of thought that calls for the rejection of Sunnah as a source of law, and recognizes only the Quran as a source of law and jurisprudence. The importance of this study is based upon the fact that it throws light on the nature of disagreement of fuqaha, whether it was a disagreement of understanding of the sources of law within the framework of the rules laid out down by them, or it originated due to the late compilation of the hadith material, and as a corollary to the fact that one of the jurists might have received the hadith on a particular issue and the other might not have. Hence the disagreement arises in deduction of rules. Here it may be borne in mind that chronologically the 6 reliable books of hadith were compiled after the establishment of juristic schools. These are generally the reasons why I want to figure out the hadith among the various other factors of juristic disagreement as the theme of my study. This seems to me to be a new approach to the subject, and it would be well warranted. This is what I shall try to discuss in my thesis, which consists of 4 chapters and a conclusion in the following order. Chapter 1. Hadith, its kinds and impacts on juristic disagreement. Chapter 2. Hadith, its acceptance and rejection. Chapter 3. Naskh of Hadith and juristic disagreement. Chapter 4. Conflict in Hadith and the rules of preference.